শুনতে পাচ্ছ ভালো? শুনতে পাচ্ছ? হ্যালো, শুনতে পাচ্ছ? দাঁড়ান এক সেকেন্ড। তুমি তোমার হ্যাঁ, শুনতে পাচ্ছ? পরিষ্কার শুনতে পাচ্ছ? তুমি ল্যাপটপের স্পিকারে দেখো শুনতে পাচ্ছ? কি
শোনা
হচ্ছে
যাচ্ছে,
ল্যাপটপ?
শোনা যাচ্ছে।
হ্যাঁ, হ্যাঁ শোনা যাচ্ছে তো? এবার শোনা যাচ্ছে ক্লিয়ার।
শোনা
ঠিক
যাচ্ছে,
আছে।
হ্যাঁ শোনা যাচ্ছে।
আচ্ছা, তোমরা আমার মিউজিকটা শুনতে পাচ্ছ?
মিউজিক না।
দেখুন তো শুনতে পাচ্ছেন কিনা। উম, এবার শোনা যাচ্ছে আমাকে? না, আপনাদের তো শোনা যাচ্ছে। শোনা যাচ্ছে? হ্যাঁ, আপনি লাস্ট টাইম ক্লিয়ার ছিলেন।
আপনার
আপনি
কথা
লাস্ট
শোনা
টাইম
যাচ্ছে স্যার।
জিজ্ঞেস করলে শুনতে পাচ্ছি। ব্যাস ঠিক আছে, ঠিক আছে, ঠিক আছে, ঠিক আছে।
না।
এবার সাউন্ড শোনা যাচ্ছে স্যার? মিউজিক শুনতে পাচ্ছেন না? এবার দেখো তো, শুনতে পাচ্ছেন?
এখন শোনা যাচ্ছে? শোনা যাচ্ছে না কেন? তুই শুনতে পাচ্ছ? বলো কি গো? এই তো শুনতে পাচ্ছি।
আপনার কথা শোনা যাচ্ছে।
ওই তো রজতটা শুনতে পাচ্ছে না।
আপনার কথা শোনা যাচ্ছে স্যার।
ও তো শুনতে পাচ্ছে না কথা, তুমি
পাচ্ছেন তো?
আমি
না,
পাচ্ছি।
কোনো অসুবিধা হচ্ছে, ঠিক আছে, আপনার সেটআপ ঠিক আছে। আমি
আমি শুনতে পাচ্ছি না কোনো কিছু।
কিন্তু এখানে শোনা যাচ্ছে পরিষ্কার।
হুম।
সরি আমার
রজত একটু ল্যাপটপটা নিচে ডাউন করো। রজতের কথা কিছু শোনা যাচ্ছে না, অডিও কি অফ আছে?
অডিও অফ আছে।
হ্যাঁ,
এবার শুনতে পাচ্ছ?
হ্যাঁ।
আচ্ছা, এবার শুনতে যখন পাচ্ছ,
এবার সাউন্ডটা দাও।
হুম,
বের করে দিচ্ছি।
শুভ্রা মন্ডল
হ্যাঁ,
লিখে দিয়েছে।
কালকে আমরা টেস্ট করলাম, সুন্দর আসছিল।
আচ্ছা, ভিডিওর পাশে নিচে না ওইখানে অডিও সেটিংস বলে, এই অডিওর পাশে একটা সেটিংস বলে জায়গা আছে, ওটা ওখান থেকে কিছু বন্ধ করা নেই তো?
কি বলছো?
অডিওর পাশে
হ্যাঁ,
একটা ছোট্ট অ্যারো আছে, ওখানে অডিও সেটিংস আছে। রজত দেখো তোমার
হ্যাঁ, অডিও
ল্যাপটপে
সেটিংস
ওখানে
আমি
কোনো।
দেখছি। অডিও সেটিংস এ লিভ কম্পিউটার অডিও আছে, টেস্ট স্পিকার, ফোন, ফোন শুনতে পাচ্ছ?
ভয়েস শোনা যাচ্ছে, সাউন্ড আসছে না।
শেয়ারিং দিয়েছি। হুম, অ্যাডভান্স সেটিংস থেকে দেখছি। শেয়ার থেকে তো আমি করেছি,
আচ্ছা।
শেয়ার থেকে আপনি স্ক্রিনটা তো দেখতে পাচ্ছেন এখন।
আচ্ছা, তোমার অডিওটা অন রেখে মোবাইল দিয়ে
হ্যাঁ,
চালালে হবে না?
হ্যাঁ, সেটা হবে। আউটপুট রুম ব্যাকগ্রাউন্ড নয়েজ ক্লিয়ার, লাইভ পারফরমেন্স একদম। না, কালকে এখান থেকে একটা অপশন দেখলাম, এখান থেকে লাইভ স্ট্রিমিং, এটা তো ঠিক আছে। এখানে একটা অপশন ছিল অডিও বলে। কত বাকি?
টাইম আছে।
একান্ন। হ্যাঁ,
51, 51 টাইম আছে।
35। Then audio. My share share call.
কম্পিউটার অডিও শেয়ার করো।
হ্যাঁ চলবে।
তো সেরকম আছে এগুলো।
লাউড হয়ে গেছে মনে হয়।
আমি তো কমপ্লিট করে গেছি। তাই আরো কমে যাবে তাহলে, এখন আরো কমে দিই।
শুটিং দেখো এতে করে।
হয়েছে?
হ্যাঁ হয়ে যাবে, ঠিক আছে। শুনতে পাচ্ছ তুমি কথা?
হ্যাঁ, কথা শোনা যাচ্ছে।
ঠিক আছে
বলছি
তাহলে
অডিওতে গিয়ে
হ্যাঁ সুবর্ণ হচ্ছে।
হয়তো 3টে অবধি সবাই ক্যামেরা মতো অফ রাখবে।
হ্যাঁ হ্যাঁ
তোমার এখন যে কোনো অফ রাখবে যখন কথা হবে না, আমরা ফিডব্যাক হবে।
হ্যাঁ ঠিক আছে।
আদর্শের এখন কনফার্ম হচ্ছে তোমার এই জয়সী মাস্টার যখন শুনবো না, তখন আদর্শের কাছে কনফার্ম করে নেবে, তাহলে আমরা অফ করবো। হ্যাঁ হ্যাঁ তখন তুমি আদর্শটা কনফার্ম করবে না, হ্যাঁ হ্যাঁ আমি কনফার্ম করবো। Hello, welcome everyone. Good morning, good afternoon, good evening, everyone. People have joined us from different parts of the world. So primarily for someone it's good morning, for someone it's afternoon. Even we are talking to somebody, we receive someone who is in the Indian time zone. So I am Ravi Bose, today your host here, and it's a pleasure to welcome you all in today's web conference on artificial intelligence and intellectual property. This is a topic, that sits at the fascinating intersection of innovation, law, and ethics. Artificial intelligence as a system, it becomes increasingly capable of generating content, solving complex problems and even mimicking, human creativity. They're also challenging long-standing principles of IP rights, uh, questions around ownership, authorship, and protections are becoming more urgent and complex nowadays with the advent of artificial intelligence, riding us through this technology advent. This session brings together distinguished experts from across the globe who will help us unfold these developments today and what they mean for creators. Basically, what they mean for creators, the business entities, businessmen, even the policymakers, and of course, society at large. So I look forward to an engaging discussions today, filled with insights, of course, differing perspectives, since we are individuals and we are coming from different, thought points, school of thoughts. So we have different perspectives, which is always appreciated, and perhaps even some forward-thinking solutions as well. With that, let's begin. Let's begin the session. Without much ado, let's begin the session. Whoa, of course, I'll not do justice if I not talk about little about LexDita. The LexDita, the organizing company, the organization, which is hosting this, today's session. It's a small boutique firm based out in India, and this organization is running such, initiatives, maybe in awareness programs, and then probably, at various points of time handles complex legal questions, legal situations. Has been a kind of boutique firm. So it's a kind of association of many, I would say, the legal brains in India. So today your hosting organization is LexDita, and I happen to be an associate of LexDita. Apart from that, I have also a kind of, I mean, my legal standing is I also kind of director of an international development organization based out in Geneva. So that's about the session. So I think, with that we can set the ball rolling. So today my first speaker for the session, would be Mr. Kevin Fournier. Kevin is a director of intellectual property, is an intellectual property firm. He's also a lawyer. He's the founder of, Kevin Fournier, Intellectual Property Legal Services Limited in the UK. So he serves many organizations and many, business. It's a law firm based out in US and UK, the European patent firm. So at any stage of, processes, starting from drafting, then, filing, prosecution, even licensing. So Kevin handles all these things. He also handles technology and IP related transactions, agreements such as investors due diligence, joint development of agreements, and IP licenses. Kevin comes with a kind of 35 years of experience in the IP field, so we can always understand the kind of, experience he's bringing in. Starting out as an USPTO patent examiner, moving on to 2 law firms in the US before joining IBM's IP legal department in the UK. So I would go back to Kevin. I would request Kevin to take the mic, and the floor is all yours, Kevin. Over to you. Thank you, Kevin. Please.
Okay. Hi, everybody. Good afternoon to most of you, and good morning to a few people. Good morning to I'm here in the morning, so yes, everything is going well, and yeah, we're in the middle of summer, so well, beginning of summer, and yeah, welcome everybody, and so yes, Kevin Fournier is my name. I am an IP attorney based in the UK and handling mainly U.S. IP matters from here in the U.K. because I'm mainly a U.S. patent attorney, IP attorney in general, but mainly patents. And I also file at the U.K. Patent Office and also the European Patent Office. I'm qualified there as well, so I can practice on both sides of the Atlantic for clients, which is helpful, to have just one person. But I also do the wide variety of things that was just mentioned. Thank you for the lovely introduction. That was really nice, and I'm happy to be here, and happy to be able to speak to you again. Thank you for that. So yeah, I'm very pleased to be able to deliver this keynote speech here at the beginning of what's going to be a very interesting conference. So, who owns the IP when AI is involved is the question. And it's not an easy question, and it's something that people are asking and courts are asking. People are taking to court around the world, and I guess it's make its way throughout um, um, the legal the whole IP infrastructure, such as contracts. Who's going to own the IP would when AI is involved would get into issues of um, like a contract law in terms of ownership. We'd have to come up with all these things. Okay, so let's start from the beginning here, where creating IP and how the laws create incentives for this. So basically, IP laws are created to reward human ingenuity and emphasis on the word human, because this is a social aspect. It's part of the society. It's the law is there to protect and reward people in society. The fruits of the human mind are being protected here with IP, whether it be patents, trademarks, copyrights, um, trade secrets, new innovative designs. All of this is stuff that comes out of the mind of a person, and the laws are there to protect people from having these, all the time and resources that a person spends, and creativity and years of experience that using their talents. The laws are assuming that this should not be stolen by somebody. Somebody can't just come along and say that person is smarter than I am. He's got really good ideas. I'm going to take them from this person, because it's easy to do so because there are no laws, protecting this. So because we have these laws, this creates a massive disincentive for others to come along and just take, the fruits of the mind of people. So the reason for the laws is to say, hey, human being, if you use your ingenuity and you create these great things, we will protect you, and you won't be able to, other people won't be able to copy you and steal it from you, basically. But then we come to technological development and AI. So AI comes along and results in machines being able to create IP instead of humans. So now what do we do with this IP that's been created by machines? Because how do we fit this into the social policy of the IP laws that I was just mentioning? Um, I think we can first think about, what would happen if this were done by an animal, if the IP were created by an animal, because I think that there was a recent famous case of a monkey taking a photo, and whether this can be protected by the IP laws. Are the IP laws looking to protect the creativity of a animal, such as a monkey? Now, uh, this is more of a random thing. The monkey just presses the button at a certain time, and the picture is taken, and the monkey doesn't probably think too much about setting up the scene, in the right way or anything. It's more random. He doesn't even know he's pressing the button on the camera. He just presses the button, and that's it. So this is much less structured and more random than AI, being involved. But it is the other extreme, I think. Humans on one side, animals on the other, and AI, somewhere in the middle. So with AI, you have rules and algorithms that are being applied um, to pre-existing IP that's being fed in. So you have um, the AI is not going to do anything if it doesn't have any pre-existing IP to work with. And when I say IP, I mean it could be photos, it could be movies, it could be articles, copyrighted articles, could be patents from the past. It could be old trademarks, but IP from the past is being fed into AI engines, and that IP is being processed by the AI engine. The AI engine will learn that certain IP looks a certain way and has certain content, and then you put in a prompt or some kind of a request into the AI engine after it's received this IP, and then the AI engine creates some new IP. So we can see there that there is some scope for human beings to get involved in the IP creation of the AI engine, because the human being has to select the old IP to put in to the AI engine, and the human being also has to decide what is the input in terms of a request, often usually called a prompt, that the AI engine would receive. Uh, so so given those things, the AI engine will create some output. So the human has some ability to influence, what the IP is doing. But this at the end, this results in new IP being created. This could be new artwork, it could be new stories, new songs, books, maybe comic books, magazines, movies. All of this could be created by AI engines. And um, so the question is, who owns the IP in the case of these new things being created? Um, so we may have seen some of these AI created movies or short videos, maybe on the internet, where there is something that would never have happened or has not happened, and but the AI engine is creating a video to show something happening that is to make something funny, maybe in politics or something, with political leaders, making them look funny or doing funny things, for joke purposes. So this is just an example. Um, the who owns this IP has not been created by a human. So when it comes to patents, um, if the AI creates a new invention for which the claims are drafted by the AI engine, and the specification and the drawings are all drafted by the AI engine, we could look for a human that is behind the creation, such as who is the human who provided the input that the AI should use to come up with a set of features, or what specific criteria to consider in solving the problem. Like maybe the human is telling the AI engine, I've got this problem, and the problem is very specific in this technological area, maybe involving fluid flowing through a pipe in a certain way, and the pipe is making the fluid flow very slowly, and then the inventor would say, please make the fluid flow faster, through this pipe. How can this happen? and then the AI might create some new kind of valve or new material for the pipe or something like that that would make the flow of the fluid in the pipe faster. So we could call the human the inventor that an owner of the resulting patent um, that set up the problem and maybe fed the old technology into the AI engine in the first place. Um, but I don't think it can be the machine itself or the AI software that would be the inventor and owner of that patent, um, because the IP laws are meant to incentivize human beings, as I was mentioning earlier, to create new IP. And if you think about it, a computer does not need any incentive. It will do what it does because it's told to do what it does. It doesn't need to be thinking that the computer needs, even with AI thinking, it doesn't need to be incentivized by anything other than the fact that it's plugged in, it's got power generated to it, and it is programmed, to do something. So the AI engine and the computer, as the creator of the IP, cannot sign legal declarations like humans are expected to do, basically saying that certain facts are true, such as I believe that I am the inventor, and like the declaration form that the inventors all have to file when they have a new patent at the USPTO. If they're lying on that form and they are not the inventor, that there will be jail time involved in the US. There's a penalty of perjury if you swear that you're the inventor, but you're not the inventor. But how can an AI engine be swearing that something is true and be threatened with jail time when it's not a person, it's a computer? Um, so it makes no sense to think about putting a computer, behind bars in jail because that's just ridiculous. All you have to do is unplug the computer and it suffers no consequence, to being in jail. So I think, because of these results that don't make sense, for considering a human, non-human inventor, we need to change. I think the IP laws will eventually need to change to create different incentives for humans again, because it's only humans that are provided with incentives, by the law, and that the law deals with, the actions of humans. So maybe we could look to the human behind the computer to see how much direction, how much content, how much specific requirements the human has given the machine. And maybe the laws would change eventually to say, if AI creates some IP, then the owner will be the human who created the most background or incentive or background or precursor material or inputting to the rules that the computer's using or providing the prompt or even shaping the output because um, um, it's it's not just a question of taking what the computer provides and that's your claim and you're going to file that as your patent application. Maybe the AI would generate something in terms of a suggested claim, and the human would then change it quite a bit and say, well, that's a good idea, computer, but I think we need to change it, to quite a bit now to add this other feature or to change the one feature that you thought that we should add and make it another feature. So, you could totally change what the computer has done but use it as a starting point. And then of course the human would be an inventor and owner of that patent. Um, so I think the human could take the computer's output. That modified version would belong to the human. Um, so there must be some level of human selection involved because I was thinking about this, and the computer could actually generate like 1,000 inventions in a second, if you just tell it to. a very powerful, computer processing farm, it could be made to generate, 1,000 inventions every second. I mean, how could all of these be protected? Practically, there's too many of them, and many of them may not be useful or the best one to file, and think of the filing fees that would be involved, and would a client want to pay that much money to file that many patent applications? The patent office would obviously be flooded as well if this were the case, so. There has to be a human involved in filtering through the computer's output, selecting the ones that are the best, and further modifying them to suit the needs of humans and the client, in terms of the client company that's paying for this in the first place. And this could be seen as invention, and this filtering process of taking the many, many outputs that come out of the AI and choosing the one that you want to select. There was creativity there involved, and maybe that would involve the laws changing. I think it probably would. The lawmakers will need to think about that, and how to best phrase the laws to cover this. So that is, I really do think that the laws will have to change in order to protect this. So I think in terms of ownership, we have the scenario where the company has done the R&D, using the AI, could be the owner. The company that's paying for the R&D, the company that is behind the research lab where the AI is actually running could be the owner. But even then, the inventors or the authors or the designers who would have to be named as the creators under the IP law. So the same issues would apply. But I think a lot of the IP creation is these days that I've seen in my career, it is done in the context of collaboration work between two entities. So it's kind of hard to say that only one entity, one company is generating and owns the IP that the AI is creating. What happens when you have a collaboration between two entities, maybe a university and a research lab? Who will own the IP then? I think that's governed by contract, usually, like the joint development agreement that the two parties would enter into. So I think IP attorneys will need to be creative in coming up with new clauses for those contracts to cover the case of two companies jointly developing, each using their own AI engine, each of which they have trained before the collaboration starts. So yes, I think in summary, this is the opening of my talk here is the opening of a very interesting debate, which I'm sure lots of you will have good ideas too. But in summary, and in closing my short talk here, AI is posing many interesting IP issues, but we have to deal with these. Possibly by changes in the law is my thought, and but we have to decide, I think, as consumers of the IP as well, of the IP created by others. Why do we pay attention to new IP in the first place, like new movies, new books, and new music? My personal view is that we pay attention to other people's IP because we want to experience the human side of whatever they're creating. If somebody creates a new song, we know it's been created by a human, and that there's certain emotion involved, with it. A certain movie's been created by a human, a director, and they've added their own human, touch and their experiences, their life. Background, has been put into a certain piece of IP, and we appreciate the IP because it is created by by a human. But what if if AI is generating this, is totally, it could be totally fabricated, totally false, totally no human element to it. So do we really want to spend our time paying attention to that kind of output? Do we want to watch movies generated by AI? I don't know. So I think we need to ask these questions as well. But the AI ownership, is very interesting, and I'm sure we'll get into more aspects as we go. So yeah, thank you everybody, and I hope you all enjoy the rest of the conference. And I will, and I hand it back to you, Rajat. You're doing a great job so far. It's going well.
Thank you so much, sir.
Thank
Thank
you
you
so
so
much
much
for
for
your
your participation, and thank you, sir.
And Ramit, yes, yeah, both of you, yeah.
Thank you.
Thank you so much, Kevin. I mean, it was wonderful. Like, this is kind of an eye opener, and you have set the ball rolling in such a way, and with the kind of analogy of monkey, which is a completely and a kind of understandable proposition, of course. But then I have a different thought. Why? Because when you talk about who owns the output, it is like there's an engine called artificial intelligence, which processes, which synthesizes my prompts, and based on the training, there are a lot of collective efforts gone into train that engine. So while this training that engine calls for many such inputs or efforts given by individuals, the engine only acts as a kind of processor. So it processes your command and the prompt which you call it as, and then gives you the output. So essentially, it's again a kind of complex question whether we'll be able to straight away say that the output, who creates the output, he owns the kind of the IP. It is something perhaps not that straight as a question to answer. So of course, yeah, as we progress in this session, we'll unfold and we'll try to answer this question. It's a very, very interesting session. I would say thank you so much again, Kevin, for your deliberation. So be with us here now. We'll move on to with a new topic called global IP policy and AI regulations. To deliver on that, we have with us Dr. Raghavinder Jier, who is a senior consultant of Department of Promotions of Industry and Internal Trade, Government of India. He is a former Joint Secretary and former Registrar of Copyrights, IPL law, and AI interface experts in the public policy. Dr. Raghavinder also previously held key positions as Joint Secretary and Registrar of Copyrights, where he played a pivotal role in shaping India's IP ecosystem. With deep expertise at the intersection of IP law and artificial intelligence, Dr. Raghavinder is a respected voice in national and international policy dialogues, legal reforms, as well as capacity building initiatives. With that, I would go back to hand over the mic to Dr. Raghavinder. Dr. Raghavinder, please come forward and the floor is all yours. Thank you. Over to you.
Good afternoon, Mr. Rajat Datta. Thanks for inviting me to share my thoughts in this platform organized by LexDita. And thanks to Kevin bringing out all the important issue pertaining to AI. Unfortunately, we don't have any international treaty or international guidelines yet to address the issues pertaining to AI. The initiative started at the various national levels. And in India, it was led by Niti Aayog, when Niti Aayog issued a national strategy for AI, AI for all. And all the departments were asked to work in collaboration and coordination with whatever AI policies they are framing. So all the government department not supposed to work in silos, but work in coordination so that using the AI with responsibility and with ethics. Niti Aayog has also come out with the two papers. One responsible AI, the first one, and the second paper is on operationalization of responsible AI, and also something related with the ethics. The best examples I see implementation, because government has to walk the talk, and that they have done implemented two important AI-driven initiatives, which I am the beneficiary. The first one is most of you must be using the Digi Yatra. When you download your boarding pass and upload in the Digi Yatra, which is Aadhaar enabled. So the privacy issues are not compromised there, and the kind of facility and ease you find entering the airport without bothering the security guard. Simply walk in, looking at the screen and blinking eye, you are getting into the airport, because the AI, the responsible AI with the protection of your privacy data, that is enabling thing happening. And second one, I remember the government has introduced Jeevan Praman, and all the retired employees have to submit every year mandatorily the life certificate that they are alive, and the relevant material has to be, documents have to be enclosed with that application. Previously, they have to personally go to the bank where the pension account is registered, and they have to give all the document, their pension papers, their photographs, their PAN card copy, Aadhaar copy, address proof, etc., etc., with one or two witnesses who have to sign that yes, he is the person who's alive and claiming the pension. But use of AI has changed everything in the Jeevan Praman. You simply download the app, register it with your pension PPO number, pension number, and which is linked with the Aadhaar. And those who want to generate this certificate, simply open that and open that QR code and look into these are all being the simple things I use. But the problem comes the lack of explainability and the responsibility in all, in general, AI is used, and the levels of the way it is used different from one country to other country, one sector to other sector. The most problematic area is a lack of the laws governing it, regulating it. And EU has done a great initiative introducing the EU AI Act, and the implementation is the second issue. But before EU has done that AI Act, the digital market, single digital market directives, which covered various issues of AI and intellectual property, especially mostly the copyright infringement related issues. The most important issue plagued everywhere, it is how the text data mining exceptions to be introduced. EU has done a good job there, that only the text data mining exceptions for the research and education can be provided for non-commercial purposes, not for the commercial research purposes, but they are given an opt-out option there. But the way the text data mining exceptions for research and education, especially for the non-commercial research and non-commercial educational purposes provided across the world, may be a little similar, but when it reached UK, the way they treated text data mining exceptions, something really shocking. It all started with giving exceptions for the users, not for the AI company itself. That is users for the non-commercial purposes, research and education. The UK, they initiated a document first and then have introduced a bill giving text data mining exceptions to AI companies. This is very shocking and something promoting the AI companies. It is very clear. As Mr. Kevin clearly mentioned that all AI, whether LLM-based AI models, Gen AI, other machine learning, deep learning models, they are using the pre-existing data, the pre-existing copyright protected works. Works here may be the literary works, articles, books, artistic works like photographs and even the films, music, etc. So all these pre-existing books, the AI learning happening, then models are created, data sets are created, then output comes. Right? If you see across the US and EU, and recently in Delhi High Court ANI case, you see that all AI companies are refusing to accept that any copyright infringement is taking place. And most of the cases filed in the UK and the US, the AI companies in the first instance, they were claiming that all these activities of AI training and this subsequent AI learning falls under the category of fair use. But they were even giving the examples of the Google Scan case, which was filed by the Authors Guild of United States, where Supreme Court of America decided it as a fair use, as a transformative nature, because the Google, the way it is scanning the books and providing, the entire work is not provided, but only the few pages are provided. It's a kind of giving information to the researchers and users how important this book or this work is for the research and for education. And that may prompt them to buy that book. And in fact, instead of copyright infringement, it is going to generate more revenues for the publishers and more royalties for the authors. The transformativeness in this thing, as explained in the Campbell versus accused music company in 1994, something is different. The transformativeness means the use is new, but no copyright infringement. I mean mirror image, that kind of reproduction taking place. A kind of new derivative work is created. So here, if you see that what kind of derivative works are created. And surprisingly, AI companies refuse to accept that no reproduction is happening without retrieving a book or retrieving information and entire scanning the book or reading entire book on how AI can pick up, do the information collection or categorization and creating tokenization, tokens, and finally a data set for its AI model, whether it is the foundation model which is creating before to promote their AI tool, that sufficient material available with the AI tool when you go and prompt it, asking a question, seeking some information by way of an output. But their argument is no reproduction happening, no copyright infringement. That is one argument. Then if reproduction is happening, then that should become under the fair use, the transformativeness is there, the way Google Books can happen and all that. And the new argument is coming up. The argument is that no reproduction is happening, it is only the memory is happening. So when something is memorized, so then which is not equivalent to a reproduction, and that is not completely copied, where direct copying is not happening. Neither indirect copying is happening. So it's not copyright infringement. This is very difficult to mm, accept. And another argument is that everything is converted into numbers. So we computer, mathematic analytical language that normal human, it is not in the readable format, that is the text format. So anything is converted in the text format. In the beginning, in input level, they say it is okay, understood, that is reproduction. But when it is in a mathematical analytical format, what normally the computer guys call it a binary format. So how can you call that reproduction? But that is a kind of, adaptation is happening. Copyright Act of India defines what is adaptation. So that is, converting one format to the other format, converting a literary work to the artistic work. For instance, a story is written, a comic story, and adaptation of that comic story and the characters into another comic book, where the artist draws the various characters and dialects are written there. It's not a complete literary work, but a kind of artistic work is created, depicting the characters, various characters, actors there. So this kind of thing is not happening. It is in the numbers. But any conversion is a derivative work, because finally the output is coming to you, and that is coming in the text format only. And as Kevin said, without pre-existing format, pre-existing copyright works, without touching them, no AI model can have a foundation model, or finally they can have a AI training, or creating AI data sets, and finally providing the output. The best example is recently been given by, I think, more than 1,000 artists from UK. They created a silent album recently. Oh, is that what you want? They name that album as "Is That What You Want?" When you when you open that album, it is a silent album, no music, no voice is found. So it is a kind of slap to the all AA companies. Now you come and scrap my album, silent album, and create music, or create a derivative work. So when nothing is existing in that album, what kind of training model it is going to create? Any LLM model or Gen AI model? So it is important. Nothing can be scrapped from the something is zero. So that is what they have taught the AI companies, and that is very surprising that still the arguments are going on, and the matter is sub judice in most of the courts. And another level happened in the Anthropic case of the Getty images, that where image conversion is done into a kind of scrambled sound is in unlike a binary number, only the something unknown sound, scrambled sound is heard when it is open. Then they say that, look, it is not infringement of photos. So these are the things are coming, and but these are all a kind of derivative works. But derivative works can get a copyright provided they pass the test of originality. How much originality is there in the works created, very difficult to understand. Apart from the kind of hallucinations happening, uh, you must have one of the persons who experienced the hallucinations, and a couple of lawyers in Canada and US had to uh, get the warning, a kind of simple punishment of a fine they have to pay, uh, and unknowingly submitting the ChatGPT drafter, affidavit replies in the court, which hallucinated and created fake um, judgments in support of their arguments and reply to the main petition. So these kind of embarrassing things happening, but the question of copyright comes. So when there is no transparency, so from which source you are scrapping the information and training your model, whether you are accessing entire book or one chapter or one paragraph, or one never knows. And nowadays, if I am correct, initially it is the perplexity started, giving a kind of citation to the paragraph, the output which is given to you. And slowly this has been adopted by now the Gemini, ChatGPT, even some extent the Copilot, and even the DeepSeek, which is the latest entrant, which use the LLM model of AI, uh, which provides most of the voice to text or text to text models. And here, the citation, what the authors and publishers are saying, it's not complete. It's not 100% citation the way we academics, when we write a very seasoned, in a seasoned journal, most important article get published, the kind of references and citation given, and it's totally different from the way the kind of citation, how I can say the off-order citation is given by these AI companies. So in one sentence, I want to say that all these AI companies are something like parasites, eating into the copyright protected content. They themselves can't create any content like humans. They can't think like you and me. I know that you must be wondering that recently, how can I make this statement that when Jeffrey Hinton, in 2024 Nobel Physics Prize winner, who generated general neural network, supposed to be the very high AI, and it is something like artificial general intelligence. Everyone is waiting. That kind of very high AI is created. That general neural networks has the capacity, he himself explained that the capacity of thinking like human. And then can it work like any thinker, the human thinker? A human brain starts working when an idea, putting idea into practice, or innovation, or a creative work. Can it going to can it do the similar kind of work and generate innovation, the new technology, and new creative works? That we need to see. And another important problem is what one research has come out that about 6 months back, if I'm correct, one AI survey company, Petronas AI, it has done a survey on all how these LLM models are working, whether the replies given them by has whether there is originality. They have studied all OpenAI's ChatGPT, Gemini, Google's Gemini, Microsoft's Copilot, and the Perplexity, Cloud, and all models available. And 85% output, the survey came out that 85% output given by them, apart from the hallucinations, they're leaving apart the hallucinations, they said plagiarism is happening. When 85% work out of the output is the plagiarized information, then how can the question, there is no question of copyrightability comes. There is no question of copyrightability, then there is no question of who is the author. Obviously, I'm the person who have been ad nauseum saying that, the intellectual property rights is totally human centric, based on the personality rights theory and human rights theory. That is the reason why for patent 20 years exclusive term has been given. The copyright started, the term of copyright when the Statute of Anne was introduced in 1910, it started with the 14 years later, 1710. And in 1832, the full-scale Copyright Act was introduced in the British Parliament. The first time they introduced the postmortem auctoris principle, that is nothing but life of the author plus 25 years. So where is the life for the machine? And my question is, artificial intelligence machine is creating has no life. Okay, then you give, instead of giving life plus 25, then Berne Convention for the international harmonization purposes introduce the life plus 50 as a minimum standard, which other countries may go ahead and give a higher duration, which other countries have given, like EU's set at life plus 70, and US also life plus 70. And the films, it is 95 years. But setting the aside, when any new law is introduced, because many are talking about introducing a sui generis legislation, sui generis act, to cover the AI related works, and whether recognizing their inventorship in the patent. You know that India is one of the top 10 patent registering countries in the software ICT, including AI, and provided these passes the test of the novelty, inventive step, and industrial application, and there should be some technical effect should be there. Otherwise, Section 3K will defeat that patentability. But here and then copyright as well, not only in the patent and in copyright. You can have a sui generis law for the inventorship, and also the authorship. But the AI created, the works created with the assistance of AI, work invented with the assistant AI, the term of protection may be decided there. Now the most of the patents are granted, even AI assistant innovations, the same 20 years are given. But in the copyright, because the given a registration to a person only, as a national person only, but creating a AI assisted artistic work, and they are recognized in that registration of that particular work that there is a originality because there is a selection arrangement, and transformativeness in that final creativity. That is the reason where they're registered. This is something disruptive news are come out. But these developments may happen, but very difficult to mm, uh, uh, give a kind of text data mining exception for the AI companies. Because I recently met producers, sorry, the publishers who are from the Reproductive Rights Association across the world, from the UK, US, Japan. Luckily, they were here in New Delhi attending Asia Pacific Conference of the International Federation of Reprographic Organizations, IFRRO, happened in the Central Delhi, one of the five-star hotels. So I come to know that few CMOs, the collective which manage the reprographic rights, they are already given licenses to these AI companies. When this licensing is happening, and then the most shocking thing, a case is pending in the U.S. Supreme Court, Apex Court, filed by New York Times against the AI companies, the OpenAI's ChatGPT and Microsoft, Google, and others. Now they are sitting across the table and negotiating. You never know. One day they come out with the finalized license, which others have already issued to AI companies. It's a copyright clearancing, collective clearancing agency. It's a RRO from the United States. And other RROs from Japan and Singapore, they are all given licensing. They finalized couple of licenses. This may be finalized. Then what is the problem here? And what
শোনা
should be
যাচ্ছে,
the
শোনা যাচ্ছে।
what kind of license they are giving? Whether it is going to be a blanket license or how they
শোনা
are going
যাচ্ছে,
to
হ্যাঁ শোনা যাচ্ছে।
distribute the collective royalty, that we need to understand. So I just take your permission, and I would like to thank again LexDita and Rajat Datta for giving me the opportunity to share my thoughts in this regard. Thank you.
Thank you so much, sir. Thank you so much for your coming here and enlightening us. Thank you so much. Over to you, sir.
Thank you so much, Dr. Raghavendra. I mean, this is such a fantastic, wide spectrum session. It was like, you started off with sharing the policy, the governance, and how it works in different countries in light of India. Then you took us to a deep dive of all technical aspects of large language model, then deep learning, machine learning, and then the binary, and others. Then you also talked about a few kind of unrest or maybe protest being done, like is that what you want? As you said, this is a kind of recent development in the UK. And ironic of that is 1832, when you talked about this, and this was passed in UK Parliament, and in UK this kind of protest being demonstrated. And yeah, of course, you have enlightened us with all the broad spectrum of AI and IP, kind of global IP policy and AI regulations. Thank you so much, sir. Please be with us, and as we progress, we'll unfold new other stories, new other thoughts. But why one thing we could I think all the other participants have they are enlightened kind of your thoughts and your threads. The thread is what you rightly said. Probably it's a slightly hard hitting word, but you said that now AI companies are like parasites. Yeah, of course, that's the kind of a thought, maybe because they are using this to ride on someone else's creativity, the originality, to produce something which is not otherwise original, because it's a kind of long, research based, well trained and long learning model through trained engine is creating the output, which is not a kind of human being. So of course there are a lot of inputs coming from this various parts of this thing, various parts of the kind of trainings. Wonderful. Please be with us. Thank you so much once again, sir. Now we'll progress. We'll move on to our next speaker. The next topic is copyright protection for AI generated content. And we have with us a speaker, Miss Darshi Mankar. A little bit of Darshi. Darshi is the managing associate of YJ Trivedi and Company. She's a seasoned expert in intellectual property, leading the trademark opposition rectification department in her organization with over more than half decade of experience. She excels in trademark prosecutions, oppositions, and cancellations proceedings. Thus, she provides strategic advices on brand adaptation, adoptions, portfolio management, and contentious matters, then consistently achieving favorable outcomes in trademark oppositions. She also drafts agreements, including franchise agreement, productions, and licensing agreements. Over to the Darshi. Floor is all yours. Thank you so much.
Thank you so much, sir. So, good afternoon, everyone. Wishing you all International Yoga Day and Happy World Music Day. I'm honored to be speaking with you all on a day that reminds us how art and mindfulness together shape the human experience. I'm also thankful to LexDita for having me. It's an absolute privilege to be part of this thought provoking platform, especially as we gather to explore one of the most pressing legal conversations of our time. Um, I'm also um, I feel privileged to be speaking after Mr. Kevin and Raghavendra sir. Um, so, moving ahead, we live in an era where machines don't just compute, they compose. As we all know, we have been discussing this aspect since a while. When it comes to machine, they paint, they write poetries, draft legal memos, and attempt Shakespeare's prose as well, and that too in a very questionable flair. Um, so, according to me, creativity is being redefined, but copyright law, it's still rooted firmly in human authorship. Mr. Kevin rightly pointed out in his discussion. So let's just begin with the familiar ground, the Indian Copyright Act of 1957. It is at its core a human centered law protecting expressions, not just ideas, originality, not just inspiration, and authorship, not automation. So, referring section 2, subclause D, the author has been well defined. The author means a natural person, a composer, an artist, a filmmaker, um, and also a writer. It assumes that creativity flows from human judgment. So now this brings to the first discussion or the pain point that can a machine exercise judgments? Can it intend to create? Legally, the answer we all know is no. But practically, AI is already creating it. So, where does that leave us? For example, imagine a marketing team uses a generative AI to design campaign, visuals, slogans, and everything is being used. The results and results are stunning. So here the question is, who owns it? Who's the author? Who deserves credit? And above all, who carries the liability? So under the Indian law, AI can't be an author. So the content, where does that content goes? It might fall into the public domain by default. And that has serious implications for creativity and investment. Now, regarding the part of that, the content, who assigns this rights? The content rights. Who owns it? The authorship. So, how do we assign rights in a world where authorship becomes blurred? If multiple people influence the same system through prompts, through training, or tweaking the content, who owns what? If we refer the same aspect in the UK law, it offers one solution. So, referring the section 9 subclause 3 of the Copyright Act, it defines the author of computer generated works as the person by whom the arrangements necessary for the creation are undertaken. I'll repeat myself, the person by whom the arrangements necessary for the creation are undertaken. Does it sound vague, or is that enough? So, moving ahead, let me take you to a moment that quietly shook the foundations of the copyright law. So, as Raghavendra sir mentioned about the 90s case, and he also presented the arguments, very recently, if we refer the case which happened in the year 2020, the Raghav case. So, the case was all about the AI tool called Raghav, the short form for the robust artificially intelligent graphics and art visualizer that was used to create a specific photograph. And the command was given that the photograph needs to be reinterpreted in the style of Van Gogh's Starry Night. And to an utter interesting fact, that the same was being applied for the copyright registration. And as co authors, Ankit Sahani, the Indian lawyer and the artist who did this work, has applied to the Copyright Office as co authoring with the AI tool. And to utter surprise, the AI, the photograph was granted copyright registration by the Indian office. But on contrary, if we look the same aspect, since Ankit Sahani, the applicant, has also applied in the multiple other jurisdictions, that is US and Canada, the results were different. The results were contradictory in nature. If I see from the US, he applied and the response was different, that without human authorship, there can be no copyright. And whereas in Canada, initially it was a flexible view, but granting registration, though even it was not possible, and hence that application is under the scrutiny. So this tells us that the global copyright conversation isn't just about law, but it's about each country perceives creativity in itself. So here I agree to the Raghavendra sir what he mentioned, that pre-existing formats are very much in requirement. Now let's just understand more about AI's darker potential, that is unauthorized use, infringement, misappropriation. So what if an AI produces an image resembling a copyrighted painting or a song echoing a famous tune? Who would be liable? Whether the user, the developer, or the platform. So referring the section 51 of the Indian law, the Copyright Act, it covers the infringement. But when the creator isn't the human, how would we be able to enforce the accountability? Once again, as Raghavendra sir mentioned about the deepfakes and the personality imitation, we are seeing much more cracks these days. That would not only be the deepfakes, but AI generated tracks mimicking the living artist, machine writing the academic summaries for it. And very recently, a judgment came that a judgment was also being written using the AI tool. So, in law, what can be enforced? It is as good as the non existent. Also, one of the fact which you all must be knowing about, that training the AI requires the content, not only the specific amount of content, but the content would be in millions and billions. It would be from books, it would be from the music, already existing films, all the data which is already there available on the internet, all hoovered up from the web, and often and most often without the consent. So Section 52 of the Copyright Act rightly outlines the exceptions for fair use. But training massive AI models, which were being mentioned by the sir, that whether it's a chat GPT or Gemini or of the Microsoft pilot, so whether these AI models, does it fit into the fair use exceptions? Whether the consent has been duly taken. The question here is the foundation of AI ethics and legality, which needs to be seen. There are other countries who are yet stepping into this consent aspect. So if we talk about the EU, so EU is introducing opt-out mechanisms, not only for the data mining. So since we are discussing about the data mining, it is all about training data, how we are using it for the AI tools. Again, according to EU, they are going ahead for the opt-out mechanisms. But when it comes to US country, they are litigating fiercely, leaning merely on the transformative use. And third country would be in discussion is Japan, who has explicitly legalized some mining methods. And here, if we talk about India at present, the upcoming aspect, as Sir said, that sui generis act is much required. There are also the aspect which we need to be seen as the moral rights, the right to be credited, the right to prevent mutilation of our work, the right to preserve our creative identity. If AI mimics my style, my brushstroke, or even can copy my tone without acknowledging it, that's not just my economic loss, that's a loss of my own self. And here, of course, we all would agree to the fact that machines may not feel shame, but they can damage our reputations at the end of the day. So, coming to the solution in our own, all everyone's perspective, as Mr. Kevin mentioned, as Raghavendra sir mentioned, and even I would agree to that, that the first, we do not resist AI, we embrace it with structure, with fairness, and with clarity. We must redefine authorship based on levels of human input, how much human input needs to be clarified by applying for the copyright. We also need the new licensing regimes so developers can train responsibility and the creators are compensated fairly. India, talking about the India, our country, should lead the world in crafting a modern copyright philosophy, one that's inclusive, enforceable, and future ready. So I would here again say that we must draw from abroad jurisdictions and the laws, but build strongly for Bharat. So this very month, India proposed new copyright rules, the draft copyright amendment rules 2025, which was proposed, and it is a shift toward mandatory online payments for licensing literary, musical, and sound works communicated to the public, enhancing transparency and traceability. But I think, however, it doesn't currently address other forms of copyright as we are discussing, using usage like adaptations or synchronization rights. So there needs clarity about it. Perhaps it's essential to uh, remember by all of us today that the core, when we are discussing about the copyright issues, the core remains the same, that the copyright was born to reward creativity. And it now stands at such a crossroads where the creator might not be the human. According to some, and as per the discussions ongoing, that's disorienting. But I would personally say that it should be taken from the view of an opportunity. So, an opportunity to rethink originality, to build inclusive protections, to craft a legal philosophy that doesn't fear the future, but it shapes it. So, on a very concluding note, let me leave you with this thought that machines may create content, but only we can create the meaning out of it. And let's together ensure our legal systems to do justice to both.
Thank you so much, Darshi.
Thank you so much, sir.
This is wonderful. This is wonderful. Let me also lend your words like, machine may create the content, but we need to kind of, make it right use of it, the content in the right direction with all kind of, ethics being maintained. So when it comes to ethics and, taking concepts to the original creators, I would say it is somewhat very, very difficult to to obtain contents, the consent from everyone contributing either through nets or through data or through any other books, periodicals, journals, whatever this machine the platform is have access to. But of course, it is all it lies on the user who uses this platform to create something new. It's a revision, maybe it's a version of the originals, but not the new per se. So yeah, of course, we need to keep, revising our thoughts. We need to keep revising our acts and the policies so that people are bound to, comply with certain regulations, which of course are all governed by ethics, or the fair usage policies. So thank you so much, Darshi. Thanks for enlightening all of us. But before I'm sure, I'm sure all the attendees, the participants here are find it really engaging and enlightening, and we need to digest the whole thing. Some point of time, sometime we need also to digest whatever we've learned so far during this session. So before we move on to the next session, I would request all of you to come on through a video. So please put on your video switches so that we can take a kind of group photographs that will give us kind of encouragement. So I would request all of you to please put on your videos, come on the camera, then so then our team can take a kind of group photographs, and we'll share this photograph, the collage with everyone. I'll just take a couple of minutes time for everyone to get ready. So if you all are there, I would say 1, 2, 3, and our team will take photographs. So are you all ready? I'm not seeing that everyone is on the camera. Please, if it is possible, please come on camera. That is wonderful for everybody. It will be an opportunity for all of us. I'm not saying that not all are on camera. If it is possible, I'm once again requesting you. Not kind of, I'm not forcing anybody, just requesting if it is possible so that it looks good on a kind of frame. We all are here. And create a collage. The sessions are actually, we'll have this. Thank you so much. Can you take a photo? Can you take a snap right now? So I'll count down this, 3, 2, and then 1. So cheers. Done. Is it done, team? Okay, thank you. Thank you so much. Thank you so much, Darshit. Please be around here. We'll move to the next session. Now we have somebody who would actually give us insights on intellectual property adopted in the pharma sectors, patents and in the public health, and the legal pathways in post-pandemic world. So I would invite Ms. Gauri Wagmere. Gauri Wagmere, about Gauri. She's the managing director of GV and leads Wise Kiran IPR. She brings a unique blend of scientific research and intellectual property as a property expert. Gauri is also a woman scientist fellow. She has been actively involved in IP facilitations and innovation support services with a strong focus on empowering innovators, especially women and grassroots entrepreneurs. Gauri works at the intersection of science, law, and entrepreneurship. Wow, such a good combination. Helping bridge the gap between research and commercialization through effective IP strategies and awareness. Over to you, Gauri. Thank you so much. The floor is all yours. Please.
You, Rajat.
Yes, ma'am. Hello.
Is my screen presenting?
Yes, your screen is live.
1 minute.
Yeah. Yes, sir.
Yes, Gauri, we can see your screen. Please go ahead. Thank you.
Yeah. Thank you. Yeah, thank you, Rajat, for giving me this opportunity, and thank you, LexData,
Thank,
also. Yeah, just 1 minute. I'm just holding it down.
yeah, sure.
Yeah. So, yeah, myself, Gauri Wagmare. I'm the managing director of Gauri Vandana Legal Services, and today we are going to hear about pharma patents and public health and the legal pathways in post-pandemic world. So why this topic is very important, as we know that how the COVID-19 impacted our lives, right? So let's go back to the basics, as we know how the patent system works. So actually, I want this discussion very effective, and I want a communication from your side as well. So as we all know how the patent system works, where they give the 20 years limited time period for the patent exploitation, where we are disclosing our technology and we are having the control over 20 years for the same. That is nothing but the patent system, and we can intensifies the patent in that 20 years period. So the inventor is having monopoly for, okay, how the patent system work in the pandemic of pandemics, generally what happens and how the system works. So government generally do different type of things, such as compulsory licensings. Also, there are few international bodies, they help to balance and create the balance in the system, where they make that the patent rights need to be given to each and every individual in the case of pandemics. Before going to the further discussion, I want to make some icebreaker questions, and I want answers from your side. So, so how many of you think patents always help to improve access to medicines? The answer can be yes, no, or maybe. So anyone can unmute and tell how many of you like, or also you can text in the chat. Another question is, can intellectual property rights ever be a barrier to saving lives? You can think
Not
of
really. Not
COVID-19
really.
scenario. Did you know India has legally issued a compulsory license to make a cancer drug affordable, which is one of the first compulsory licensing case?
This is wonderful. This is wonderful.
Yeah. And who do you think should own an AI discovered drug? Is that the programmer or an AI company or no one or the public?
This is what is the question of this session, like, who owns the output? So
Yeah.
this medicine is also the treatment is also kind of output of any research. So research is based on a kind of AI platform. That's the question, and we're trying to find out the answer.
Yes. So that there is the gray area lies, right? So we don't know the answer exactly, because in Indian perspective, the answer may be different. In the foreign perspective or European, or there are so many countries, right? So they are having a different kind of rights, and we don't know what is exactly the answer. So let's see the another question. In a pandemic, should life-saving medicines be treated as a global public good? If your answer is yes, then why? And if your answer is not, then why not?
Yeah, of course it is yes, because this is for the mankind. So saving mankind is something which should be done voluntarily, whether we have a patent or not, whether we are using it in India, or we are using it in Europe, or in any other country. I mean, irrespective of that, it is saving mankind from a devastation. So it should be used. Yeah, of course.
Yeah, right. So let's see another thing, like go to the basic again. So understanding the IP rights in the pharmaceutical sector. Okay. So what is a patent in pharma? So it will definitely gives the 20 years the exclusive rights to make, use, and sell that technology or any drug or anything which is patentable. Okay, it prevents others from manufacturing or selling the generic drugs during this period, right? Because if someone sells the generic, then definitely the infringement case will happen. And under TRIPS as well, there are some restrictions intended to reward innovations and encourage investment in the R&D. So these are the 3 points which can we say that yeah, patents in pharma, it is place in that domain, and it will open this to make, sale, and use for the 20 years, right? Let's see another question. Should life-saving innovation funded by the public be patented and sold for profit?
Yeah, from the human angle, it is not. From the business angle, it is yes.
Okay. So what will happen when there is a pandemic situation and due to intellectual property, there may be a situation for crisis? In that case, let's see the case of COVID-19. So patent can create a barrier for technology transfer and generic productions, right? Also, delays in access affected lives in the global south. And the TRIPS waiver proposal, like which is given by India and South Africa jointly to sparkle the global debate on IP flexibility during the pandemic. And it has happened, and we have seen and we have gone through that. What happened at the COVID-19 and how we need to be prepared for such kind of disasters or crisis situation. Let's see what COVID-19 taught us about IP and public health. So there are so many inequalities, global inequalities, we can say, which are exposed during COVID-19. The vaccine treatments were deployed rapidly, there is no doubt. But as we know, high-income countries secured more early doses, and the low and middle-income countries struggled for access. So vaccine hoarding versus global solidarity, it is one of another thing where concept of vaccine nationalism emerged, and COVAX aimed to distribute equitably, but fell short due to limited supply and IP barriers, and we have gone through that. What about the TRIPS waiver and debate? As India and South Africa proposed waiving the IP rights for COVID-19 tools, they sparked the global discussion on health versus IP protection. Also, they resulted in limited waiver in 2022, too little, too late for many actually. So that's why each and every person haven't got the vaccine on the proper time. So what about the public funding and private control? So many vaccines, such as Oxford, AstraZeneca, or Moderna, receive the public R&D support, but still the IP rights remain privately held, and they are restricted affordable access, right? So it will serve as a double-edged sword. There are pros and cons. So this drive innovations, but and global investment also takes place a major part for the development. But what happens when that drug leads to very high prices, right? In the pros, it encourages the pharma companies to develop novel treatments. Definitely, they will take the patent rights over the same because it is novel and the different, technically advanced. But what will happen if the delays generic availability due to patent, and especially in low and middle income countries? And it can also having a con, that is can limit access to essential medicines, right? So in case of HIV virus, in case of hepatitis C or cancer, they need to be affordable to make a real world impact. So because for that, developing countries need to enforce it properly, and also WHO need to support that. And there are so many organizations such as Medical Patent Pool. They are also doing a very great job for pooling the patents and license it. So the global IP rules don't always account for the public health emergencies, but they need to be changed in such scenarios. So in the case of COVID-19, once again, let's see what happened. So COVID-19 pandemic brought the global health system, pharma innovation, and legal framework under intense security. We know that it happened in a proper way, but a little bit like we cannot give the same thing to each and every individual. Why this topic matters? Because inequalities in the healthcare access, which is a big issue. Also, it will violate the Article 14 for the Constitution, equality before law in the Indian Constitution as well. So each and every person in India as well as in the world need to get the healthcare in a proper way if there is a pandemic situation, because we have to see each and every person in an equal way. So there is an urgent need to rethink the legal pathways that balance the innovation and the public good. So that kind of thing need to be happened, and that can make a wake-up call for all of us. If not only the COVID-19, there are so many kind of emergencies will going to happen in next to 20 to 25 years. So there is called as one disease X kind of thing, that maybe the next pandemic may happen because of that. The pathogen is we don't know what exactly will going to happen, but the preparedness is better solution for these kind of situations. And this is the race for vaccine development, but it may serve the inequality in vaccine and medicine access. And rich countries stockpile the doses while poor nations struggled. But in case of next pandemic, it should not happen. So for that, this one is a wake-up call, and we need to think on it. Also, how the AI will help to make the new drug discoveries. So in case of bioinformatics, through that, we can make so many things easy. Other technologies, other drugs we can make by using the computer integrated systems. Okay. But if that systems are like totally AI implemented, so in that case, in that scenario, the question is there, who will own the rights? So that is another thing. Let's see the TRIPS agreement in case of a global IP framework. So it is an acronym for trade-related aspects of intellectual property rights. It is a WTO administered treaty, which is setting the minimum IP standards for all member countries, and requires the patent protection for pharmaceuticals in all member states, or it limits the national flexibility to produce imported generics without permission. Okay, so what happened in the case of TRIPS waiver? So in a revised TRIPS waiver proposal, which is submitted in May 2021, originally submitted by India and South Africa in October 2020, and the proposal called for the temporary waiver of certain TRIPS agreement provisions to allow countries to produce COVID-19 related health technologies, because there are few things which are restricting the making COVID-19 vaccine in a effective way. So without to solve that barrier or to stop the barriers in from the TRIPS, we have made that waiver proposal. The revised proposal is again submitted in 2021, and in 2021 it is accepted, and around over 20 countries are co-sponsored in that case. So it is not the issue for only India, it is also the issue for so many countries. What it focused on, especially it focused on the health products and technologies. So in the case of COVID-19, the COVID detection kits are there. Also, the formation of different kind of mRNAs. Okay, so vaccines and therapeutics or in diagnostics and related components or the methods of manufacturing, they are actually getting benefited. So these kind of things are really important in that scenario, and that's why the waiver will passed with the voting. So let's see the another organization in that how the patents get collected and voluntary licenses are made possible, and how the medical patent pool will work. So medical patent pool do so many things in that they have done one excellent job related to the HIV virus, HIV drug. So that is a dolutegravir. So DTG, we can say it as a DTG. And over 24 million people living with HIV are get benefited because of that thing. So DTG is supplied across the WHO regions by generic licenses, and they sublicense it to so many companies. It is the basically the patent from VII Healthcare Private Limited, and with the help of their technology only it is possible. So the credit is go to VII as well, VII Healthcare and Medical Patent Pool. So if any inventor want to go for a patent which they want to give it in a voluntary license, they can connect with the MPP and do the great job. So let's see what exactly the DTG for HIV treatment. So it is actually the antiretroviral drug, and it is used for treatment of HIV. And it is patented by VII Healthcare Private Limited. So what the medical patent pool did, so in 2014, VII Healthcare signed a voluntary license agreement with MPP, and MPP sublicensed the drug to multiple generic manufacturers. So definitely that case goes to MPP, and then after MPP will take everything out of it. Like MPP will take the charge of it, and then they have the sublicensing rights, and they sublicense it to multiple generic manufacturers. And definitely the production and distribution is allowed in 92 low and middle income countries, as they are having connections over there. As MPP is actually UN based, and UN will support the MPP. And it is very easier if we connect with MPP and then do our sublicensing. So the generic versions become available at a fraction of the original prices. And what is the impact? So if any drug which is in a dropped prices, which is less than the $5 per month per patient, and definitely it is accessible to each and every patient, then which improved the viral suppression rates and the better outcomes. So then we can say that that is the main benefit of patent, like only making a technology and getting a patent and commercializing it, it will not pays everything. When you create a real impact in the world, which is nothing but the social impact, then definitely we can say yes, the technology is utilized in 100%. So, and why it matters that without MPP's intervention, millions would have faced delays or denials in access due to high cost and patent restrictions. So MPP plays a very good role in this case, and definitely for hepatitis C and tuberculosis and cancer as well, they will do so many things in that case. So for us, what are the future takeaways? So shaping an equitable and innovative future for global health, which need to be prioritized and which need to be taken care of. So innovation is there, definitely it is there, but it need to be coexist with the access. So when the cycle will going to fulfill, when we're having a good innovations, and then we are having a impact due to that innovation. So we must rethink the pharma IP framework to serve both innovators and public good. So in a balanced way, we need to think about it. Definitely there is R&D cost associated with it, but there is a rule of multiplication. when through MPP as well, if you get only 1 or 2% of royalty, but if you increase the beneficiary pool, definitely that multiplication will lead to the greater outcome. So we cannot say that by giving the voluntary licensing, we are not recovering our R&D cost. We can recover it, definitely, but we have to reach each and every person which need that drug or which need that technology. So the future innovation should be inclusive, ethical, and need driven. Also, there are legal tools such as compulsory licensings. Also, TRIPS is giving the flexibility. They are acting proactively. Expand initiatives like Medicine Patent Pool and so many organizations, they are doing this kind of things. So we need to avail the benefit from them. Also, the policy changes are also very important in case of national emergency or public health emergencies. There need to be flexibility, and we have to cooperate that by making the policy changes. So how to embrace the emerging technology responsibility in case of AI? Okay, in AI and drug discovery, here the IP law must evolve to address ownership and access, as we don't know who owns it and uh, how each and every person assess the benefit out of it. So ownership, it is one of the gray thing which is not yet discovered in a proper way. We need to think on it. We need to evolve the laws against it, and definitely better reforms will come around it. And also the open source research models need to be encouraged, and public private partnership or also the like technologies need to be made in the academia and research institutes, and they need to be tied up with the big industries and pivot in that way. That is also one of the important thing we need to do it in the future. Definitely, there are so many academics and industrial research which are collaboratives and they are made. But in the case of AI, also we need to rethink on it, how it need to be integrated, how the ownership is need to be decided, and how the reforms need to be made around it. So equity is not optional and we need to think on it. It is very important thing. And justice in healthcare is not a charity. It's a legal, ethical, and humanitarian obligation. So the goal is not just survival, but dignified and affordable care for all. That need to be our goal. So my final words, the true taste of innovation is not in what we create, but in how many lives it can save. Yeah. Thank you, guys. If you have any question, you can ask.
Hey, thank you, Gauri. This is really enriching. In fact, this happens to be a different kind of, thought-provoking areas which we discussed about in the pharmaceutical sectors, the healthcare sector, which is extremely important. Of course, post-pandemic, it has become further more relevant and important for all of us. While you was delivering your speech, I was just wondering, I'm sure somebody will also share the same kind of thoughts. Like, I was just wondering that what a big impact a patent and IP can have on pharmaceutical, because it is always seems to have double-edged sword. Like, whether to have patent or maybe to make it free for public to use. With a patent, it has a shelf life of 20 years. Then it goes generic. Then people will have the affordability. So yeah, of course, so we are such a I mean the big world it is with so many countries, and if you have an affordability, if you do not have affordability. So with all these things questions, you have left out to the thought the participants to discuss. But of course, as we still try to find out the answers, who owns it. So let's I mean live with the thought and let's be around with us. Thank you so much once again. We'll come back to you during the Q&A session. Now, we move on to the next session, which is equally important. I would say also very kind of fascinating. That is The topic is IPR ecosystem for startups and educational institution. Now, in the world of startups, there are also impact of IPs and applications of IPs. So to deliver it on this, we have today Miss Asa Rije. I would say just to talk a few words about Esther. Esther is an advocate based out in Kenya, advocate of High Court in Kenya, WIPO certified trainer and a certified professional mediator. Esther currently serves as an associate at the company Morara Nyamya and Company, and where she focuses on matters relating to intellectual properties and the commercial law. Esther's passion lies in raising awareness on IP rights and empowering communities through accessible and practical legal knowledge, which is wonderful. Thank you so much, Esther. The floor is all yours. Over to you. Please, I'm handing over the mic to you. Thank you so much. Esther, are you there?
Yes, thank you so much, Ramit.
Thank you.
Allow me to share my slide.
Okay, just wait. Let me give that. Yeah, I think the right is given to you. Esther, please. Esther, are you able to share it?
No, I'm not able to share. Or
Did you try to
maybe
share it so that we can get this triggered and then we can give you the access?
I'm not able to share it.
What are you going to get on the screen when you're trying to share this screen?
Just a minute. Okay.
We are not seeing anything from your side because it will
Yeah,
prompt me that you're not trying to share. Then only we can give you the access, please.
okay, perhaps I could just speak because
Yeah, please, and keep trying so that you can also, or maybe you can send your presentation on this platform. We can try it out for you.
okay. Okay, I just sent to Rajat.
Okay, we'll just know. You have sent it to Rajat, right?
Yeah, the email.
Okay. We'll just share for you. Just give me a couple of minutes.
Yes, sir. In which mail you have shared?
You used to share the Zoom link.
Yeah, just hold on. I'm just checking my your email.
Oh, yes, Esther, we have received it. Just give me 30 seconds. Is this the one? Yeah, of course. Please.
Yes. Okay, thank you so much for inviting me to this webinar organized by LexDita. And it's also a privilege to be speaking after great speakers. Next slide, please. Okay, I'll be looking at the title, Understanding Traditional Knowledge in the Era of Artificial Intelligence. So what is traditional knowledge? Imagine traditional knowledge is a tree whose roots are deep into the earth and the branches are reaching across generations. Each leaf is a story, a remedy, a tradition. This is how I view traditional knowledge facing the winds of artificial intelligence. So our journey today will cover what traditional knowledge is, its evolution, the policies supporting it, challenges and opportunities in this AI era, and the India's game-changing traditional knowledge digital library. So traditional knowledge is the heartbeat of communities, and it's the wisdom that is passed down orally, like stories told around, a fireplace. These are stories that guide everything from healing with plants to preserving seeds. And therefore, traditional knowledge is holistic as it weaves spiritual beliefs, ecological, and social traditions. Globally, 70% of India's population relies on traditional knowledge for healthcare. And traditional knowledge is not just history, it is a living, breathing part of our identity. Next slide, please. Thank you. We are now looking at the phases of traditional knowledge. Traditional knowledge has indeed evolved, as you can see. We have the agrarian era, we have the industrial era, the knowledge economy era, and the artificial intelligence era. Now, in the agrarian era, traditional knowledge was the backbone of survival, where farmers used it to predict the weather, healers used it to craft remedies, and then followed later was the industrial era, where machines overshadowed this wisdom. Industrialization era was one that was filled with mechanization. And now in the knowledge economy, traditional knowledge was also ignored in research laboratories. In this era of artificial intelligence, traditional knowledge is becoming digital data, but the catch is that there's increased risk as artificial intelligence can scrap this knowledge without permission, without consent. And we see that over 30% of modern medicine comes from traditional knowledge, yet communities often lose out. So in this evolution of artificial intelligence, it demands that we act to protect traditional knowledge. Next slide, please. So are there policy interventions to help in this issue. Yeah, I'm proud that Kenya has a separate act of 2016 for traditional knowledge and cultural expressions for the protection of traditional knowledge, and it requires consent and benefit sharing, and this ensures that communities profit from their knowledge. Equally, South Africa has its the Biodiversity Act with access and benefit sharing. And regionally, we have the African Regional Intellectual Property Organization, that is in Africa, which has its Swakopmund Protocol for the protection of traditional knowledge and folklore. And most recently, last year, we saw the WIPO Treaty adopted in May 2024, which is a game changer because it mandates patent applicants to disclose the origin of genetic resources and associated traditional knowledge. And this is good because it's towards a fight, it's towards to fight biopiracy. And an example of biopiracy is the Hoodia plant, which is associated or belonging to the San people in the South African region, that's the global South, that was patented without their consent. And therefore, with such policies intervene to ensure that there's fairness for such communities and also benefit sharing. Next slide, please. Now, with the rise of artificial intelligence, we see that it's reshaping research, creativity, and decision making. Because artificial intelligence depends on massive data, often scrapped indiscriminately, which raises ethical issues and ownership questions. In this AI age, traditional knowledge faces big challenges, such as, next slide please, such as ownership, Now, who owns the TK communities? Who owns the traditional knowledge? Is it the community or the state or the corporations? And on issues of documentation and exploitation, we see that there's risk of misappropriation, especially during digitization. So in as much as AI is here, it has both, it's a double-edged sword. I'd say it's a double-edged sword. It's come with the goods and the bads. It's good to digitize, but the risk is that there's a higher risk of misappropriation without consent, and the communities at large also do not benefit from it. And under exploitation, you know that AI models, because they are trained on data, they extract information from large data sets, and traditional knowledge is not excluded. And on opacity, there's lack of transparency in AI systems. So these are some of the challenges that we are having. And the quote we have today is that when data is knowledge and knowledge is currency, who gets paid? So that's just a food for thought. Next slide, please. So in as much as we have challenges, and amidst challenges, there are opportunities. And now what can be done? What can be done to protect this traditional knowledge and the AI that has come to, scrap information? So what can be done about these challenges is that we need to develop sui generis laws. And these are special legal systems which are uniquely designed to protect traditional knowledge, especially in the age of AI. So such laws should include clauses that directly address how traditional knowledge is used, stored, shared by the AI systems. Secondly, we should integrate and adopt the CARE principles. And this means that innovation must serve the collective, the respect community requires, the authority the community has to uphold responsibility and be grounded in ethics. And lastly, it is important as holders of this knowledge to push for transparency. If AI models are trained on traditional knowledge, communities must know and have a say. Innovation must be ethical, inclusive, and ancestral. Next slide. So we are looking at a perfect example of the India's traditional knowledge digital library. And I'm really inspired by this, as this library holds 454,000 formulations from Ayurveda, Unani, Siddha, Yoga. And it's important to know that this digital library has been translated into 5 languages, and this is to curb issues of biopiracy. Through this traditional knowledge digital library, 324 patents applications globally have been stopped. Some have been amended. For example, the turmeric patent in the US, and this has saved millions in legal costs by making traditional knowledge accessible to patent offices. Traditional knowledge ensures fairness. So the WIPO Treaty builds on this, and it encourages global databases to be established, just as India has given us the best example, and in fact, one in the whole world. Next slide, please. Yeah, I believe I'd already spoken about what needs to be done and why we need to do it, to develop the sui generis clause with AI-specific clauses, and of course, to integrate the collective benefit authority, responsibility, and ethics principle into mandate transparency in AI models using traditional knowledge. Doing this will enable us to prevent the misappropriation of traditional knowledge. Next slide. So, as the holders of traditional knowledge, so if we participate in data governance, so it should not just be about protecting traditional knowledge, but we should also talk about how the traditional knowledge holders benefit from it. So as traditional knowledge holders, we can have a seat at the table in AI governance frameworks, as this will shape how knowledge is used. Further, traditional knowledge holders can negotiate benefit sharing agreements. And this means that if a company profits from such knowledge, the community shares in those benefits. Building digital knowledge repositories with access control is also important. South Africa has a national recordal system which offers secure controlled access. And we've also seen India's perfect example of traditional knowledge digital library. And therefore, as digital IP literacy is vital for communities, such communities must understand their rights in the digital economy. And as we have seen again, India's traditional knowledge library is proof that this is possible. And therefore, we are urged to replicate these models and scale the benefits of such repositories. Next slide. So as I finish my presentation, picture a vibrant tapestry. Each thread that is a piece of traditional knowledge that is woven by communities worldwide. And include policies such as the WIPO Treaty, the regional treaties, and the various national laws and tools, such as the India's traditional knowledge digital library, which strengthen this tapestry. So, and such tapestry ensures that AI respects our heritage. I believe that we can empower communities with fair laws and digital vaults which help protect traditional knowledge for future generations. Imagine indigenous peoples who are just 6% of the world safeguard 80% of biodiversity. And therefore, let us honor their wisdom in safeguarding this traditional knowledge. Let us respect their traditional knowledge. Thank you for joining and for listening to me.
Thank you so much, Esther. Thank you so much. I mean, you have brought up a different dimension altogether. You talked about traditional knowledge, which was maybe much overlooked, subject when we are discussing AI innovation and other thing, because there is a huge repository of traditional knowledge, not only in India, but also in all other countries. So you raise the basic existential question that, who owns this traditional knowledge? Is it the community or the government? Be it state government, be it the provincial government, the country. That's very, very, important questions to want us to address before we actually take it towards the ownership. And you also talked about embracing care policy, the care principle, which we all appreciate and understand that it takes a longer time because it's a huge framework which involves all stakeholders, starting from community, individuals, society at large, then the government, maybe, kind of, global treaty and all other things. So it is, of course, this is something the most sought after situation maybe, but, it's a long drawn process, but of course, we must head up to that. Thank you so much. And I just, taken, cues from one of your code that you have written that, when the data is knowledge and knowledge is currency, who gets paid. So just to add my little bit up there that when data is a whale, then information is knowledge, and information is currency. Like, and knowledge is currency. Who owns it? Thank you so much, Esther. It was really kind of enlightening session. Be with us around. We'll come back to all of you because once the next session, we'll progress. I apologize. I turned your session as a different, with a different heading, but your session was traditional knowledge and AI. I apologize for that. Thank you. Now we'll go to the next, probably the last section of our session, which is I discussed earlier, this IPR ecosystem for startups and educational institutions, which is also very, very interesting subject. And to deliberate on that, we have with us Ms. Swati Pandey. Just a little bit of Ms. Pandey is an accomplished officer serving as assistant controller of patents and design at the patent office in Kolkata, India, under the Department for Promotion of Industry and Internal Trade, which is again part of Ministry of Commerce and Industry, Government of India. With expertise in patent examination, innovation facilitations, and IP awareness, Swati plays a vital role in strengthening India's patent administration system. Ms. Pandey is actively engaged in assessing patent applications across diverse technology domains and contributes to the implementation of national IP policy and procedures. Thank you so much, madam, for being with us. Floor is all yours. Over to you. Thank you.
Thank you very much. Am I audible perfectly?
Yes, you are audible. Thank you.
Okay. So first of all, thank you for the very beautiful intro and a very good evening to all the participants. Today, my topic is IPR ecosystem. So let me share something if I can.
Share
The share button is not working properly. I don't know. Is sharing available?
Yeah, madam, please. Just give me a couple of seconds time. Please try now. You'll see the button right now. It's active, the share button.
It's not working. It's not working, I think.
We have made you host, madam, so you should be
Okay,
having access to that.
just give me a moment. Is this available?
Yes, we can see your screen. It's on Zoom window.
Fine, fine. Just give me a moment. Yeah, is this available?
Yes, we can see you.
You can see my screen?
Yes, we can see your screen.
Okay, very well. So, yes, today I have been given a topic, IPR ecosystem. So you must be aware that eco is something which is related to the globe and the world and system, which actually coordinating with the different types of units. So let it be health or climate, anything. The IPR acts a very pivotal role in achieving the global needs. So how IPR is actually helping? So let's come to a point where innovation is actually important. So what is innovation basically? The innovation is the creation, development, and implementation of a new product, process, or service. So when we talk about the new enterprises or the MSMEs or the startups, so the products, process, and services are really very important because they make USP for the system. And as we know, there are a lot many startups are coming and they are famous because of their USP. So let it be like I have given an example, cred system. You must be aware nowadays it is very famous because for a person like me, who forgets the things. So cred actually makes me memorize that your credit card bill is pending and all the credit cards are assembled in a one place. If you people are not using it, kindly start using it at an earliest. It is of very use. So innovation is actually is the act of introducing something to new to a company. So let it be a product or a new market strategy or any new method. And what is IPR ecosystem? So IPR ecosystem actually provides you a legal framework where institutions, practices, or the stakeholders involved in creating, protecting their management and the enforcement of their intellectual property rights via various tools like the Patent Act or international treaties like TRIPS agreement and anything. So innovation is basically an integral part and is a very unique variable and a decisive factor in an enterprise, which is really necessary for element for newly built businesses or startups. So when we talk about the IPR or the startups and MSMEs, what are the government aids or the government facilities? Because I am from a government organization, so I'll let you know because the 15-minute times is really a very short period of time. So I'll highlight the important points which ultimately helps you to know what are the government of India flagships. Okay. So when we talk about startups, SMEs and all, so one thing comes in our mind, that is the Atal Innovation Mission. So AIM. So I want to focus because this is really a very important mission, and every person who are new to the the IPR regime, they should know what is Atal Mission. So it's an innovative of Government of India flagship to promote a culture of innovation and entrepreneurship in the country. And their objectives basically is
to develop new programs and policies for fostering innovation in different sectors of the economy. So, the startups, like, startups and small businesses, they are working for innovations, and they should know that the IP, how IP really helps them to build their resume. Okay. So, this Atal Innovation Mission basically provides you the platform and collaboration opportunities for the different stakeholders. And it actually creates awareness and umbrella structure to oversee the innovation ecosystem of the country. So initiatives of Atal Innovation Mission are like, our government is not only focusing when we acquire something after a certain age. Our government mission is to enable the young minds to think innovative. So for that, the Atal Innovation Mission is establishing Atal Tinkering Labs at school levels. Okay, the kids of class 6 to 12, they can have this facility. They have all the new facilities which they can utilize for innovative minds. Now, when we talk about startups and entrepreneurs, the AIM, the Atal Innovation Mission, has Atal incubation centers at different levels. And for the unserved or underserved part of India, there are many places in India still they don't know the technology and all. So the Atal community innovation centers, they encourages actually a spirit of entrepreneurship in the underserved regions of India by providing enabling infrastructure facilities and by creating the environment of innovation. Now, for the advanced technology, they are still like, the Atal mission is working in each and every aspect of the country, let it be from the young minds, the kids, or the advanced technology. So Atal New India Challenge, the ANIC, it is called as ANIC. So ANICs are basically the products and solution based on advanced technologies in areas of national importance and social relevance through a grant-based mechanism. So basically via ANIC, you can get the grant and you can work upon the advanced technologies of national importance. There is Arise ANIC challenges, where the national initiative to promote research and innovation and increase competitiveness of Indian startups and MSMEs. They are also providing some sort of mentor. So the proactive leaders in a various, regimes of our country, they are voluntarily giving their time and expertise to guide and enable the students to experience, learn and practice future skills such as design and computational thinking and all. So this is important to know what is a startup and who qualifies for startup in our country. So this is the chart of IPR applications, which is showing how the patents design applications are actually, they have increased from 2018 to 19 to 2020 to 23, a 50% rise in the filing of the applications. So what is the startup? So startup is basically, as per the Startup India, for a period of 10 years from the date of incorporation, registration, if it is incorporated as a private limited company or registered as a partnership firm. So registered under Section 59 of Partnership Act or a limited liability partnership, these qualifies as a startup. And there are few things which need to be fulfilled, like the turnover of the entity should not go beyond rupees 100 crores in any of the financial years from the establishment. And also entities working toward, this is very important because the aim of our Atal innovation or anything, the IPR ecosystem, is to promote the culture of innovation in our country. So for a startup to be qualified as that, the entity is working towards innovation development or improvement of products or processes or services. If not, then also it should be a scalable business model with a high potential of employment generation or wealth creation. So, and there is one exclusion, like if you are splitting from a previously existing business, you are not qualifying or not considered as a startup. So, what is the need for an IPR? So, an efficient, equitable intellectual property system can help all the countries to realize the intellectual property potential as a catalyst. So, actually, IPR acts as a catalyst for the economic development. The more the IPR, the more the economy and the more the well-being of the social and the culture. So you know all that, and if not knowing, then IPR is basically working in a quid pro mechanism. What this quid pro is a legal term basically. So it's a for you have to give something in return of something. So this is a very good balance between the interest of the innovators and the public interest, and how the innovators are benefited and how the public. So when you are doing some sort of innovation, you have to give the full disclosure to the government, and the government publicizes it for the benefit of the public. And in return of that, the innovator is actually receiving an exclusive right for a certain period, which actually bars others from selling, making, and using of their products or services or processes. So this is a quid pro mechanism. As we talk about the startups, so startups are basically the 80% of their growth is based on their IP portfolio. So yes, IPR is very much important for the startups. Now, why IPR is relevant for them? So why IPR? As we talk from global health to addressing the issues of climate, the intellectual property is actually an important element in policy making. This is actually acting as a fuel. So maintaining a robust intellectual property ecosystem that fuses innovation and creativity is imperative for a better and sustainable world. So, however, it is really a challenge for countries where there are low, the income of population or poor resources are available. So, the economic development and social and cultural well-being is basically dependent on how strong IPR of a startup is. Benefit for startups, like the government is encouraging the startups to come for the IPR protection. And what are the benefits and startup is getting from the government? So they are getting the reduction of fees in the filing or examination of their application. So when we come to our office for filing an examination for the startups, the fee is reduce as compared to others. So what else you can avail as a startup? You can have the facility of expedited examination. There is a provision in our Patent Act, if we talk about patents, that you can have the facility where you can expedite your application by filing for expedited examination. Also, the government is providing you a facilitator. So what facilitator is doing? So facilitator is provided under the SIPP scheme, and what are the charges for those facilitators is being given by the government back to them. You need not to give the charges of the facilitator. Who can be eligible for startup or small entity, small entity education institution in India? So as per Rule 2FB of Patent Act, an entity in India recognized as a startup by the competent authority under the Startup India initiative. So when in case of a foreign entity, an entity fulfilling the criteria for turnover and period of incorporation, they can also go for startup. When we talk about small entities, so small entity is clearly defined in Rule 2FA of our Patent Act. So in case of an enterprise engaged in the manufacture or production of goods, an enterprise where the investment in plant and machinery, and it should not exceed the specified limit, then they can qualify for a small entity. When we talk about educational institution, so Rule 2CA of Patent Act clarifies who can qualify for educational institution. So it can be any university established under the Central Government Act, a provisional act, or a state act, and includes any other educational institutions where they are actually receiving any sort of grants or authority designated by the central government or state government or the union territories in this regard. I told the SIPP, so it's basically the Startup Intellectual Property Protection. So what is the purpose of this SIPP? So SIPP basically provides you the scheme for facilitating, the startups or the small businesses. So it is being launched in 2016 and is extendable up to March 2026. The scheme is implemented by Office of CGPDTM that provides facilitators to startups for filing and processing their application. So what facilitators do? They help you in processing and filing of your application for either it is patent, design, or trademarks. And what are the professional charges? The professional charges of the facilitators are being reimbursed by our office. So SIPP aims to promote awareness and adoption of intellectual property rights among startups. This scheme is inclined to nurture and mentor innovative and emerging technologies. Who can apply for SIPP? So any startup certified by the Startup Certification Board, any Indian innovator creator who files an IP application through any TISC established, like TISC is a center established by WIPO for technology and innovation. Any educational institute fulfilling conditions specified in Clause F and Clause HX of Rule of Patent Act 224C. An eligible Indian applicant filing an international patent application as receiving office in India. Okay, so who can be facilitator? This is important to know for the patent agents, like a patent agent registered with the CGPDTM, trademark agent, or advocate defined under the Advocates Act 1961, a government department like TIFEC, NRDC, they can qualify to be a facilitator. There is one term I want to highlight under the SIPP, like IP Mitra. So IP Mitra is for facilitating startups in patents, trademarks, and designs protection under the scheme. For facilitating startups, intellectual property protection, IP Mitra can provide assistance in filing, support, and facilitate in processing of IP applications. And they can also help you broaden one's IP portfolio. So I think with this little knowledge and the time provided, this things are important to know. And yeah, one more thing, there is one also Kapila initiative by the government for higher educations, where you can have a grant for the IP for the IP portfolios or IP applications. So Kapila is basically the Kalam program for IP literacy and awareness, and it provides a financial assistance to the institutes that are part of higher education and which will create appropriate, and this Kapila is beneficial because they are creating IPR awareness, they are funding, they are providing you IPR courses in the colleges, UG, PG and PhD level, and like these are the grants they are providing. So with that knowledge, I think in this the available time, this can I just explain. And if you want to know more, you can log on to our www.ipindia.gov.in. Yeah, thank you very much.
Thank you so much, madam. Thank you so much. We have actually, enlightened us about all the government schemes starting from IP Mitra till Kapila and other things for the startup organizations, how government is going to incentivize them and encourage them. So all these things you have to trust upon. It is important that all of us must understand that our government, for that matter, any government in any other world, they encourage startups because startup is one of the pillar in this the financial ecosystem, and which is very kind of aggressively growing up. So I mean, for them, there's also literacy program. For them, the awareness program is there. Then they have also single window, facilitation centers. All these are there. So with any other business entity being it established, and for startups, it is extremely important. And I mean, that's it. So thank you so much again, madam. So please be with us. With that, I think we have almost at the back end of the session. Now, since we don't have no further deliberations in the session, I would request all and participations. I'm sure people have numbers of questions and they have so many things being incited, and they probably have even points to counter. So all these things are there. I would request all of you in this Q&A session, be proactively participate, raise your hand. I'm sure all of my guest speakers, the lecturers, the deliverers, they would love to take, and they don't mind to take few hands, subject to their availability and the time constraints. We are almost on time as far as the schedule is concerned. I think we can still take another 5 to 6 questions. Please raise your hand. I'll take 5 or 6 hands maybe. Again, depending on the time, we might extend it. So the floor is open. I would only request all the participants who would like to ask any questions, mention your questions, come on the camera, take the mic, ask your question, and then if you have any particular person to take these questions, you would like someone to take this question, please mention the name. We'll pass it on, and I am sure they'll be happy to take those questions. So thank you again. Please raise your hand. I would be able to take 5, 6 questions maybe. Over to the floor. The floor is open. Please raise your hand if anyone has any questions. Perhaps I have seen that the chat box is flooded. So anybody has any questions to ask, please raise your hand, and I'll just pass it on to the right person to address it. Thank you. Well, I see one hand from Elena Ghosh. Please, if possible, yeah, come on camera
Yes.
and ask your question. If you can, also suggest who take the question, that would be better. Thank you. Over to you.
Sure. I won't be able to switch my camera on given a few internet issues.
No problem.
But yeah, I have a question for Miss Gauri Wagmare. So first of all, I would really like to thank for the session. Like all the sessions were extremely insightful, and yeah, and especially Ms. Gauri ma'am's was something that a lot of us might have not thought about it in that detail before. It was quite enlightening to me. I have one question for her. That is that given that, as you said, uh, that even in terms of say humanity, that it is good. Like it would be great if people would come out and not argue for patency for in life threatening situations like say a pandemic, but then when it comes to patency we see an idea of responsibility being attached to it. Say if a person is asking for patency, that person will also be held responsible if something goes wrong. Again, it also comes to the people who take it. So my question is, just in case, if we argue for in the world of medical, in the medical field, if we argue that we do not need patency for some drugs, that too in times of extreme situations such of a pandemic, what would happen in those situations? Just in case, if we choose to take a drug that has been proposed by some country, and since there is no idea of patency, they can't be even held responsible later if something goes wrong. The other follow up question on this is that what would be the motivation for the people who develop these drugs? Because anyway, patency helps them to sort of make money out of it, but then in such cases, they also need to have some motivation to make a good quality drug. So, what do we do to address those areas?
Thank you so much, Elena. This is a very, very valid and genuine question, and this, has its own kind of merit. Unfortunately, we don't get, Gauri here. She's dropped, I believe. And I'm sure since this is a targeted question, it makes sense that, she picks up this question and answers back. So what we'll do is, the entire session is recorded. We have taken note of your question. I'll pass it on to Gauri. We'll pass it to Gauri, and we'll come back to you. Maybe through different kind of communication thread, or maybe in general, we'll set it out for everyone to know for their consumption. I'm so sorry, and I would have, I didn't notice that Gauri is not there. She has dropped for some reason. So we'll
That is
definitely pass this
completely
on to question to others. Yeah, please. Elena, did you say anything?
No, sir. I just said thank you. That would be great.
Sure, I'll come back to you. Thank you so much. Anybody, anyone has any other questions? We have with us Kevin. We have with us, I think, others are also there. We have Ms. Swati Pandey with us. We have Darshi Wankar with us. So if you have any questions, or maybe in general, if you have anybody, any other questions, we are there to, facilitate this. Is there anyone who has any questions, specific question to ask? Well, if not, I think we might, Elena, you have the question once again?
Yes, sir. I had one open-ended question. This can be answered by anyone per se. Like everyone did mention that it's a very vague scenario at this point. But then this is particularly for applications. That, for example, now we see that platforms like ChatGPT or Grok are also helping in programming. So now, just in case, if someone sort of develops an app through a program generated by ChatGPT or Grok or whatever platform they use, uh, who should ideally get the patency if this person files for it? Now, I understand that there are two thoughts of understanding here. One, that the developer of Grok or the developer of the AI platform, what they have, like how they have developed it, the mother company per se. But then there also is a point that how this particular user might have trained the particular search engine to work as. So again, we have that point. Then we also have that point that these say AI platforms, they sort of use almost all the available data that is there online. So in these cases, like in such a scenario, who would ideally get the patency for the particular app? Or if a particular person goes and asks for it, will that person get it?
Thank you so much. Thank you so much for your question. May I request anyone, maybe Kevin, if you would like to answer this question? Kevin, you are mute. You are mute, Kevin.
Oh, hi. Okay, now I'm off mute. So a very quick summary of the question. I think if you could just, Elena, just summarize it very quickly, because yeah, that would be really helpful.
My question, sir, was that given a situation, if a person sort of develops an app by using an AI platform. Say these days AI platforms are also programming for people. So who would in such a case, like if this person goes to file a patency for that particular app, who would get it? The mother company who has sort of developed the AI platform, the person who has say trained the AI platform to work for him or her, catering to his needs, or or is this in a very vague space where the given the fact that the AI platforms use almost all the data available?
Okay, yeah. So, I think the inventors, according to most countries in the world, would depend on who came up with those particular elements of the claim. Claim one, for example, that are novel and inventive and define and solve the problem of the prior art. So I don't think it would be the platform, the AI platform, because they did not probably come up with those elements. It may be, like I was saying earlier in my talk, it's likely to be the human who actually instructed the AI to go on this path of solving this particular problem and gave it the requirements that would be required to solve the problems. I think that's probably the person or the entity that would be the inventor and the owner.
Understood, Kevin. Thank you.
Okay.
Thank you, Kevin, for your answer. Beautiful answers to the point and apt answer. Elena, and we see Gauri is back. If you could repeat the question for her, it will be easier for her to answer this question. Over to you, Elena, please.
Yeah, sure. So first of all, Gauriman, thank you for the very enlightening session. My question to you was that given a situation, as you mentioned, that in an emergency situation like a pandemic, where we need drugs or whatever medicines in an immediate need. So for the sake of humanity, if we could give up on the question of IP or say patency at that particular point of time. But again, if we look at the idea of patency, it also comes with the idea of responsibility. For example, if I make a drug, I am responsible for its effects. If we remove the entire idea of patency from it, one, how will the idea of responsibility come into this? Because given that in those times people are really desperate for an answer or a way or a solution to what would be the motivation for the makers or the developers who are making the drug. If they are not able to at the end make money out of it, will it not lead to careless casualness in those times?
Yeah, okay. So thank you for this wonderful question. Yeah, this is really a good question actually. But when we see any pandemic come, so we don't know exactly what need to be done for that kind of situation. Okay, so particularly not only one patent will help for such situations. So there are so many pool of patents which are cross licensed to get the exact final version of technology which we want. Okay, and before that, if there are the regulations which restrict that pooling of the patent, then that is very harmful because the time lapsed, that is the time will go in that to change the behaviors or to get the permissions from the authorities and to get the permission from each and every country and each and every inventor, each and every owner. The time limit, it is also need to be taken care of, and that process need to be make very effective in that scenario as the case is very exceptional. And in that case, if suppose what will come first in case of law as well, we know that any person who need that drug in the time of emergency need to be treated equally, right? So in case of least developed economies as well, it need to be provided on the time. because the scenario is totally different. So in that case, our priority should be given to the humanity, not to the commercialization, or not to the getting benefited by that technology. And it is not about only one patent. It needs a cross licensing of various sort of technologies, and then to make the exact standard operating procedures for giving the drugs. Also, the drugs need to be prepared in a different way. So in that case, definitely we have to take care of that part of our conscious, that the humanity is above each and everything. And definitely we will get benefited later by that thing as well, by giving the voluntary license, where suppose we are serving so many people in only 1 rupees, then definitely how much quantity amount we are getting, it is definitely a bigger one. Instead of giving the serving only one person in 1 lakh, right? So that multiplication factor also plays a very main role in that. And in the exceptional situations, we have to amend the laws in a very expedited way, and then do the other things, because each and everything need a time. So also the material transfer agreements will come across. So in that, the binding things or the non-disclosure agreements are also there. So that things plays a very a huge role. And the technology transfer and the licensing is one part where it will not happen in 1 day. There are so many things are involved in it. And in the case of emergency, we need to be that much of responsible to do all these things in a very effective way, where we need a policy or the framework for such things. Suppose tomorrow some disease will come, okay? And what happened in the case of COVID-19, the same thing will happen in this case, suppose. Then which thing we need to put first? That is very important. And we need to ask ourselves, also our system need to ask that key, which thing is very important for us. Hope you got your answer.
Yes, ma'am. Sure. Thank you.
Yeah. Okay. Thank you.
Thank you so much, Gauri. Thank you, Elena, for this question. So we have seen questions on the chat. Someone is writing about the question that we used to use the search engine before AI for capturing data. So if those works can be copyrighted, why not work with AI? So that's the question basically. And then it went on elaborating the whole thing. Is there anyone who can take this question? Or maybe, it is just, to be left as a kind of food for thought to answer this
Which
question.
question is it?
Sorry?
Which question is it? Can you please repeat?
Yeah, there's a question like, I have this question. Someone has written like this. Before AI also, we were using search engines. And those were capturing data. So if those works can be copyrighted, why not work with AI? AI cannot create work without a human prompt. Even a simple prompt, if it brings an exceptional output, should it not be copyrightable or IP protected? So that's what the question is. So against the existential question, like, someone is giving a prompt, which is an intelligent prompt coming from the kind of, intelligence, and then putting it on a system, and the system, applies its logic, fetches data from various sources, and then gives output. So the question is like, whether this output should be, copyrightable or IP protected. This is the exact moot point on which we have, initiated and then, conducted the entire sessions, and people have, deliberated on this. So yes, sitting today, we don't have a definite answer to this. Of course, the wish list, it is in the wish list that should be copyrighted, but again, subject to certain validations, and then probably there'll be a lot of protest around from the originators, from the people who have originally created something. So this tussle will continue for some time unless we have a clear-cut definition or clear-cut law in place to protect intellectual property the right way. particularly the helm of an advent of AI being widely used. So I think this is something which is yet to be answered. But yes, of course, this is in the wish list. That has to be also very kind of original work to be considered as the original work. Then it must be protected.
Yeah, in this case, we can just assume that we each and every person can say their ideas on this. Okay, they can do it in a panel discussion or in the gatherings. So how we can do, like how we need to think on it. Suppose so many people are using the or making something which is created by AI, but for creation of that thing, they need to give some specific kind of input. Okay, and then only AI will make that thing for them, right? And in that case, suppose the input is very different, or it is not a generalized form of input, then definitely the creation made by that input is definitely different. And in that case, it need to be protected. But the ownership also, that is a different way of thinking, that is it lies to the AI, or is it like combined with that engine, and as well as the prompt which whom given. Okay, so maybe the combined benefits, like it is in that in the case of traditional knowledge also, the benefit sharing clauses are there. So maybe that thing will go in this manner as well, like how the benefit need to be shared with the engine, as they are also made that kind of engine, or the owners of that engine, and also the prompt giver, because they are also applying their some intellect to give that kind of prompt, right? So I don't know what exactly the answer, but maybe this kind of things will like this kind of law need to be mm, come around in 5 6 years. Maybe we will see so many case studies regarding this, and we will understand it in a better way.
Thank you so much, Gauri. Thank you so much for sharing your perspectives. Yes, of course, this is a unique perspective, and everyone has kind of their own right to share their thoughts and perspectives. Until unless we arrive at a consensus collectively across the globe, and it's not between a kind of within confined geography. Maybe it's a kind of a global question, and there are people to answer these questions. So with that, let us take it forward into the vote of thanks. And the closing notes, I would request the founder director of LexDita, Rajat, if Rajat can share a few words. And with a vote of thanks, we can conclude this program. I'm sure people they have so many things scheduled over the weekend. So let's not drag it further and hold them back. Thank you so much. But for sure, I'm sure all the attendees must have enjoyed the session, and we wanted your feedback. We wanted your serious feedback so that we'll make it even better during the coming sessions. Thank you so much. Over to you, Rajat. Thank you. Thank you very much.
Thank you so much, sir. Thank you so much for your kind words and your support and your guidance. I am truly blessed to have you with ITEC, LexITEC. Uh, Distinguished speaker, esteemed guests, and participants from around the world, it is my honor and privilege to deliver the vote of thanks and formally bring this thought-provoking session to a close. Today's conference is a theme of AI innovation, rethinking IP heritage and health. It illuminated the dynamic interplay between cutting edge technologies and involving framework of intellectual property law. From rethinking traditional IP system to exploring the ethical and regulatory challenges of AI in the health and cultural prevention, we have navigate some of the most critical questions of our time. In the meantime, I am pleased to share that we for that conference we have received confirmation registration over the 250 participants. representing more than 25 countries. And the event has garnered interest from 50 plus law firms, 15 university, and 20 plus corporates entities so far. So it's show how the AI and innovation is the future of our ecosystem. I would like to extend my deepest gratitude to our chief speaker, Mr. Kevin Furnier, sir, Director Intellectual Property Legal Service Limited UK, for his global perspective on AI governance and IP reform. Our sincere thanks to Dr. G.R. Raghavendra, sir, uh, Senior Consultants, IPR, DIPP, Government of India, whose insight bridges the cultural gaps between policy and public policy, AI regulation, and IP jurisprudence. We are grateful to Mr. Swati Pandey, ma'am, Assistant Controller of Patent and Design of Patent Office Kolkata, for highlighting the role of India's patent system and adopting emerging innovations. I would also request, I also share my special thanks to Dr. To Miss Darshi Mankan for her compelling perspective of IP litigation, arbitration, and the age of AI. She is our, she is our regular speaker like Kevin sir and Darshi. We are very fortunate to have all of you in our past conference as well as in upcoming conference as well. I would also like to Miss Gauri Bagmare and Miss Esther Vijay for thank you for their bringing the unique viewpoints of making this forum diverse and enriching everyone. And I would like to extend my special thanks to Mr. Rajiv Datta, partner of WebScript, and his dedicated team for their visionary efforts in developing customized IT solution that integrate AI into legal and health sectors. So your contribution perfectly embodies the spirit of innovation and that conference celebrated. I would like to express that at LexDita, we are deeply committed to building the bridge between technology, law, and policy. The platform like Global Web Conference Series and the Legal Tech Meet are our humble contribution towards that mission. I would like to thanks to all of our attendees, partner, and Mr. Ramit Bose, Director and Head of Initiative at United People Global (UPG), and I'm very fortunate to have sir in my LexDita as a senior associate as a guidance, and with her leadership, we will hopefully we will achieve what we want to do. And Mrs. Shubha Mondal, she is associate of LexDita for her dedicated effort to make it happen. Let's carry the forward the spirit of collaboration and curiosities. Let us continue the questions to innovate and to build system that not only protect innovation but also empower society at large. This conference, we are we are associated by NIPAM also. They will, all the participants will get the certificate from NIPAM just after 2-3 days. And I also like to announce our next event that will be happened on 12th July 2025. You know, for like IP, we have planned to make it a green initiative for our next event as well. You know, we take it as a like a single a per participation. We will uh, uh, we will will plant a single plantation for every registrations or every participation. So this is our next initiative. The our conference next conference will be held on 12th July 2025. With that, I formally bring this conference to a close. Thank you. We will look forward to seeing you again for our upcoming events. Stay connected, stay inspired. Thank you, sir.